Healthcare Headlines. I'm Amber Walsh, Chair of the McGuireWoods Healthcare Department. Today, I will be speaking with McGuireWoods partners, David Pivnick and Michael Podberesky. Both of these seasoned litigation partners have extensive experience representing various stakeholders in the healthcare industry on healthcare fraud matters. While David has led the McGuireWoods healthcare litigation practice for many years, Michael comes to us with a different perspective, having recently joined us after serving as a federal prosecutor in the DOJ civil fraud section. David, I'm going to start with you and ask you to share with us what you see as the key areas of government focus right now.
Perfect. Thank you, Amber, and appreciate the opportunity to speak about this today. I think the number one area for the government right now, whether on the civil side of the house at DOJ or criminal side, is the opioid crisis and enforcement relating to opioid abuse. I think it's been that way for a couple of years and will continue to be at the top of the priority list. There's a lot of reasons for that. The biggest one being it has a lot of different legal angles, whether they're pursuing physicians for overprescribing, selling prescriptions, issues with prescription pads not being secured, looking at some of the pharmaceutical companies, looking at marketing schemes in connection with opioids. There's a lot of different angles which the DOJ is pursuing, and they're looking at it both as a criminal and civil matter. And beyond just the dollars and cents that are at issue, because it has such public health significance, it really does resonate with people. And so it's really a top of line enforcement priority on both sides of the house at DOJ. Second and third behind that, and I think they're both, in my view, at least several steps down, but still high priorities, is elder care and things of that nature. So home health, hospice, and nursing facilities. I think those have gained an increased spotlight in light of COVID and some of the issues that have come up in the past years, as well as some of the funds associated with nursing facilities. But there's also a lot of issues, and we've seen a lot of cases arise in the connection of hospice, 6-month rules and things of that nature. So I think that will continue to be a priority for the government. And then the third, which I think is, again, moving rungs down, but important, pertains to managed care. And I think underwriting all of that is there's a high emphasis on the government from a legal theory standpoint on anti-kickback cases and enforcing the anti-kickback statute and false claims cases that arise out of purported violations of the AKS.
Yeah, I guess it really should be no surprise that those are some of the top priorities in terms of fraud prosecution. Those are also a lot of the priorities that have driven some policymaking and statutes and regs as well. So that's not surprising that these are top concerns.
Absolutely.
So specifically, obviously, we work a lot as well in the healthcare private equity industry. Do you see any increase of FCA litigation relating to PE funds specifically?
I do, and representing a lot of private equity funds, it's unfortunate that I see an increase in this area, and it's one that I'm called to address for clients more often, whether it's getting involved in diligence and assessing risk in connection on a buy side or sell side transaction, or defending active litigation. I'd say if you had asked me this question as short a time ago as 3 to 4 years, I'd have told you I really don't see much activity involving private equity funds in the connection of fraud enforcement, particularly in the healthcare space. Over the last few years, that's changed a fair amount. I think the good news is, by and large, the cases that are coming across my desk are not instances in which private equity funds are being brought into the litigation strictly by virtue of having made an investment in healthcare. There's usually other ties and other dynamics that are in play, such as the private equity fund being aware of a concern prior to a transaction and having a price concession but not taking affirmative steps on a corrective level afterwards, or the private equity fund being actively involved in structuring or the creation of the purportedly improper scheme. So it's been more direct involvement than simply private equity funds being named, but we're certainly seeing it increasingly. And as private equity funds continue to have a larger presence in healthcare and involvement in the entities that they have majority or even minority stakes in, I think that will continue. And the other thing I would note on this front is, for better or worse, there's obviously a fairly well-coordinated relators bar, the whistleblower bar, in the false claims space. And they have the right, whistleblowers and the general public has a right to file False Claims Act litigation on behalf of the government, and the DOJ then has the ability to investigate itself and intervene, and the whistleblower can continue the case if the government declines. And I think that's relevant here because particularly with some of the softening in the economy and unemployment numbers over the last year and a bit, those tend to portend an increase in future false claims filings. And the whistleblower bar is very coordinated. And if they think there are deeper pockets that they can pursue, even if there might not be a valid legal basis to do so, I expect we'll continue to see private equity funds named in some of these filings, which will put a premium on good board hygiene and operations and compliance and making sure that we're able to respond vigorously when those arise, both to address the substance of the underlying allegations, but also any potential allegation brought against the fund itself.
That's interesting because you mentioned there basically some points of contact in the continuum that the fund can have with the investment throughout the operations, but you also referenced, I think you're referring to the diligence stage. So I think you're referring to a situation where something is identified in diligence, and in lieu of really properly fixing it, correcting it going forward, the fund potentially takes purchase price concession or some other avenue of protection without really fixing it, which can be viewed very differently, I'm assuming, by the government, than if the fund is willing to come in, roll up your sleeves, fix it, deal with whatever you're going to do in the deal economics, but fix it and be part of the solution.
That's exactly right. And I think most clients take it as a given. And I would expect my clients to take it as a given that on a go-forward basis, the operations are going to be run in a compliant manner and that they're going to get the ship steered and heading in the right direction. I think the bigger question is if you know that X liability has been identified from the past, or at least there's a particular theory of wrongdoing, making sure that you've actively evaluated that risk, determined whether a self-disclosure or refund is going to be required or appropriate, and then socializing that with whether you're the seller or the buyer to make sure that everyone's on the same page, I think is very important. And where I become particularly concerned is if a client is looking at it and saying, unfortunately, this doesn't come up very often because we represent sophisticated clients who I think understand the dynamics in play, but looking at it and saying, well, we're buying here, we need to obtain, concessions on purchase price, as you alluded to. And that's just one example, but they don't take the proactive steps to correct going forward. And all of a sudden the government can very easily perceive that as a situation where they've now benefited as well from this wrongdoing. And the government is sort of the only entity that's not been made whole, which creates a whole different dynamic. And it looks, frankly, and feels very different. So making sure that you're not just addressing the risk from a business standpoint, but also actually fixing things on the ground with the underlying platform is very important.
Sure, absolutely. Let's shift gears a little bit. I want to bring Michael certainly into the conversation as well. So Michael, maybe I'll start with you on this one. Thoughts on how to handle a government investigation or being served with process. So practical tips on the undesirable situation and how you respond to that.
Sure. And just to echo David's words, Amber, thank you for having me and glad to be here at McGuireWoods. So the first thing to do if served with a subpoena or a civil investigative demand is read it. It sounds obvious, but there will be clues in the subpoena itself that will tell you the basis of the investigation, a sentence or two. And then specifically for civil investigative demands, look who's signing the subpoena. If it's signed by the local U.S. attorney, then it's likely the matter they have concluded the matter is worth $10 million or less if all the allegations are proven true. If it's signed by the director of the civil fraud section at DOJ in Washington, then that is a clue that they have concluded the matter is worth $10 million or more. So right there, you already have some indications of what kind of the scope of the problem you may be dealing with. Immediately after reading it, you should be on the phone calling and retaining counsel. There's very tight statutory response timelines 20 days for documents and information, as little as 7 days for oral testimony. And once counsel is retained, within a day or two, they should really be reaching out to the prosecutor, the line attorney, who will be identified in the subpoena, and setting up a meeting so that they can accomplish several goals. The first thing, you're opening up the lines of communication and hopefully gleaning information about the investigation. What are the allegations? What are the claims? Two, you can narrow the scope of discovery. Prosecutors tend to write very broad discovery requests in case they have to move to compel. But in reality, what they want is a much smaller universe of documents. And defense counsel can work with them to really narrow the scope and burden and cost of discovery. And you can also establish reasonable deadlines, right? So the 20 days is a placeholder. If you have a meeting with the prosecutor, you can hopefully get that extended to something that's more reasonable, a rolling production schedule. Once that production schedule is in effect and the sort of the wheels are in motion, you want defense counsel to rapidly conduct a thorough internal investigation so that you can get your arms around the problem and formulate a defense strategy. And listen, once the government goes overt, they've been covert, I don't know, it could be a year or two that they have ahead of you. And you want to catch up to them and hopefully get ahead of the government. Find things on your own, get your arms around the story. Hopefully find things that you can show the government you're cooperating. You can educate the government as well. More generally speaking, I think particularly in the civil context, the False Claims Act context, you want to be as transparent and forthcoming with the government as possible to the extent that makes sense. And most of the time that will make sense. The False Claims Act context, there's a lot of play in the joints. The government declines to intervene in about 75% of the whistleblower cases, which means the prosecutors are really open-minded. They're willing to listen. There's too many cases, not enough prosecutors. So they're in a position where they have to decline most cases. Unlike other offices at DOJ, where once they open an investigation, they're very likely to bring charges. That is not the case with False Claims Act cases and the intervention decision. And finally, my last piece of advice is retained for False Claims Act matters. You want to retain experienced False Claims Act attorneys. False Claims Act is not a criminal case where an iota of doubt is enough to sway the jury and get rid of a case. It's preponderance of the evidence standard. So implausible, but theoretically possible, that might fly in the criminal context. It's not going to move the needle in the FCA context. And finally, FCA is not run-of-the-mill civil litigation. The government is not your typical civil litigation. This is not a breach of contract dispute where both sides are throwing mud at each other. You probably don't want to treat the Department of Justice in that fashion.
A little biased from your perspective of having been at DOJ, right? Feeling the abuse at times and knowing that that's not always an effective strategy.
That is fair.
And Amber, if
sure, David, I'd love to hear. Yeah.
Sorry, thank you. Just a couple quick adds that I would make to what Michael just said. One to emphasize a point he made, and another just as an addition. One of the things I also advise clients is to have a plan if the government comes knocking. And all the steps that Michael just advised are spot on in terms of best steps and best practices once you've been served with the subpoena or CID. But all too often we get a call from clients who are caught completely off guard, as you typically would be, and that's by design by the government. But they sort of welcome the agents in. The doctors have had discussions already, and part of what we're then having to do is play catch up on what did you discuss, where did you discuss it, what did you give them, what did you tell them. So having a plan that sort of outlines who internally is to be contacted in case the government does show up, what the government's rights are, what you're obligated to do and to permit if and when the government comes. It's obviously very different between the government executing a search warrant versus the government serving a civil investigative demand. So understanding and having some very basic training and a plan in place that covers this potential, what the type of service could be, and what it ultimately means for the entity and how it should be handled. I think that ounce of prevention can be worth a heck of a lot in the long run if and when the government comes knocking. And as a practical matter, with approximately 700 on average key TAM whistleblower cases filed annually, plus investigations that the government is conducting on its own on both the civil and criminal sides, that's 1,000 plus investigations a year that we're talking about. And while that number seems large, I recognize in the scheme of the number of healthcare businesses there are in the country, it's not that many. There still is a possibility that one day you're served with a subpoena or CID. And so I think having a basic plan in place and understanding some of those parameters is really important. And then the only other point that I wanted to just emphasize that Michael made that I think is worth doubling down on is Michael's spot on the numbers that 75% of cases the government declines to intervene, which means the government is no longer going to be prosecuting it. The whistleblower can continue if he or she so chooses. The other statistic that dovetails with that, and I think tells the whole story, is the government recovers about 90% plus, 90 to 95% in most years of its dollars when the government has intervened and prosecuted the case. So the government is declining 3/4 of the time, but recovering the vast majority, 90% of its money from that 25%, which is to say all of those steps that Michael just outlined in terms of taking things seriously, conducting an investigation, and really drilling down on it and trying to get ahead of things and to be able to put your best foot forward in front of the government, explain what happened, where things may have gone wrong, or why you did everything right, assuming that's hopefully the case, is critically important. Because if you're not able to make that argument and the government determines that it's going to proceed with intervening, they're telling you that they think this case has a lot of meat on the bone. They don't have to do that, and more often than not, they don't. So being in a position to really focus, not just wait for the lawsuit, so to speak, but really get ahead of it is incredibly important. And I know that can be costly, but it's inevitably money well spent in light of those numbers.
David, I want to just pull out one nugget that you said a couple of moments ago.
Sure.
And this can be a very overwhelming conversation, certainly for healthcare providers of really any size, but the small to mid-sized healthcare providers. But you made a reference to the ounce of prevention and having a plan in place of even just who is allowed to deal with a CID or speak to a government investigator or be able to answer those questions. And that seems like a very simple step that any healthcare provider can put in place, even if you don't remember all of the steps here and you just take away, call a really good experienced lawyer, having that plan of who can react and speak. And that should be very natural for a healthcare provider to do. Most healthcare providers already have a plan in place if they're a facility for when a field surveyor comes in to do a surprise survey. So there's typically already a plan in place. It would just be a natural extension of that. So I just wanted to pull that nugget out. I thought that was helpful.
Absolutely.
Let's turn now and kind of wrap up with having you both share some thoughts on fraud recoveries in 2020, but also shifting then towards where we might be going in 2021. So starting with what you can share about fraud recoveries in 2020. Any highlights, lessons learned from the past year that was crazy in many ways, but also had some interesting healthcare fraud recoveries as well?
Sure. Well, Amber, I've got some top line numbers that DOJ published in January for 2020, fiscal year 2020. So the total False Claims Act recoveries were $2.2 billion, and $1.9 billion of that was healthcare related. Those numbers were down about 40% from the prior year. And I attribute that to two blips. One, pandemic, which shut down courthouses, it shut down the ability for investigators to interview witnesses and accomplish other tasks they need to accomplish. And then two, there were two very large settlements, both related to opioid manufacturers, for a combined $3.6 billion that were announced within 6 weeks of the end of the fiscal year. So one in October and one in early November. So those recoveries were influenced by these very large settlements, which did not count in fiscal year 2020, but will count in 21. And so I think you will see a large upside blip in 21. That said, I think the trend, I think there's durable statistics. There's statistics that show there's a durable increase in False Claims Act matters and recoveries. Most importantly, in 2020, there was an increase of about 20% in the total number of cases, 920 up from about 700 and change. And of note, there was a dramatic increase in non-whistleblower cases. So these are cases that DOJ brings on its own. And that is the fruit of a years-long initiative for DOJ to do more statistical analysis, get ahead of problems and unearth problems on their own, not just react to whistleblower complaints. So I think the seed corn is there to see an uptick in enforcement. And along those lines, I think with the new administration, I think we've seen early signs of a commitment to increased enforcement. I think the early picks to lead the CFPB and the SEC are both known for being very pro-enforcement. I think we're headed for, at least in the short and medium term, for more enforcement in the next 1 to 3 years.
David, anything to add on top of that before I close us out? Any tips or additional thoughts in the realm of healthcare fraud enforcement?
No, I think that was well stated. I agree with Michael's general conclusion that I think we're going to see an increase in activity continue to rise. I think that was well stated.
Amber, if I could just make one more point. The other gorilla in the room, and I referenced it earlier when talking about the blip in 2020, is the government is spending a lot of money right now. And a lot of that is going towards healthcare providers, the Provider Relief Fund, PPP loans. So that is also going to be the impetus for more enforcement over the next 1 to 3 year time period.
That is a great point. We saw that first case come out about a week or 10 days ago on the HHS relief funds. Came out a lot more quickly, I think, than many of us in the healthcare legal community expected. That was a fairly extreme situation, but it certainly caught our attention that, fraud in PPP loans, HHS relief funds, other CARES Act dollars, it's going to be taken seriously and in the not too distant future. So that is a great point.
David and Michael, thank you so much for spending a few minutes with us today on healthcare headlines. This is obviously a hot topic for suppliers, providers, investors, and other stakeholders in the healthcare community, and we appreciate you sharing your insights. Thank you.